Good morning and welcome to the Historic Courthouse. We have two arguments on this regular calendar this morning. Williams versus United States, numbers 23-30355 and 356, and BDO USA PC et al. V. Giosabata et al. Case number 23 CV 1046. Good to see you both again, counsel. Please go
Good to see you
ahead.
as well, Your Honor. Good morning, Your Honors, and may it please the court. Adrian Madsen on behalf of appellant David Andrew Williams. I'd like to reserve 4 minutes for rebuttal. Your Honors, this court's en banc 1996 decision in Vini versus United States does not bind this court for two broad reasons. The first reason is that the question presented in Vini took place under a subsection of the statute that has since been repealed and is not at issue in this case. But second, even looking beyond that, even if this court were to find that Vini would otherwise have been on all fours with the questions presented in Mr. Williams' case, Vini has been abrogated by statute. That is, at the time of this court's decision in Vini, this court relied on the absence of a statutory requirement that there be a statement of reasons for declining to sentence someone under the YRA. The YRA, of course, has since been amended to expressly require a statement of reasons for declining to sentence someone under the YRA. Second, even if we look beyond the abrogation, the clear abrogation by statute, the reasons for this court's reviewing only to determine whether the court was aware it had the discretion in Vini no longer apply as well.
But Mr. Madsen, I get your argument as to Vini. But I mean, your brief raises more specific claims of error about particular applications of some of the factors, some of those which I think are well worthy of discussion this morning. But under your argument about Vini generally, I mean, what did the trial court do wrong in that respect here? I mean, it's got a, 8-page order that goes through every single factor, 7-page order that goes through every single factor and explains its reasoning, perhaps incorrectly on some of them, maybe not, but I'm not sure what the Vini error or the error under the amendment to the statute is really.
Sure, maybe I can rephrase this a slightly different way. That is, in my view, Vini is no longer good law. That is what Vini relied on to hold that no statement of reasons was required was at the time in the statute that is quoting from at 430 to 431 of Vini. A statement of reasons is thus explicitly required when a DCYRA sentence is imposed, but there is no comparable requirement that the judge explain his reasons for imposing an adult sentence.
And there was some debate about that in the other writings in that opinion itself, right?
Sure,
So,
absolutely. There was debate, but my point is in saying, Your Honor, I don't
that
mean
we
to
could
interrupt.
look at the more specific errors, right?
Yes, that is that but even now, right, we don't even have to look back and say, was Vini correctly decided, because the council has answered that question by requiring under 903D an express statement, a written statement of reasons, right?
Right, that's what
So
I'm
the
saying.
question is whether what we have here complies
Right.
with that.
Yes, Your Honor, and so looking beyond the issue of reviewability that the government has raised, this court would review for abuse of discretion. That is just like it reviews for abuse of discretion under the IRA, a statute animated by very similar principles containing very similar factors, just like this court has reviewed other sentencing related decisions such as treatment in lieu of prosecution for chronic alcoholics in Cruz and in Clay, right? So this court is reviewing for abuse of discretion. And to your question, both Judge Ruiz and Judge Shanker, the specific claims of error that Mr. Williams raises are under that abuse of discretion
Okay,
standard.
so I see. I think you were getting at the government, what you're characterizing as the government's argument, which is that we really shouldn't be saying much at all as a court of appeals now, looking at this, because the trial court could do almost anything. Okay, I get that, and I'm not sure that really resonates with me anymore either. So, but would you agree that under the current version of the statute, what the trial court said here, putting aside specific claims of error in application satisfies at least the statute's requirement of a written explanation that is then reviewed for abuse of discretion as to its particulars.
Sure, absolutely. Yeah,
Okay.
yes, that is the trial court gave a written statement of reasons. I think that satisfies 903D. It's just that, in my view, the trial court abused its discretion in the manner in which it made that decision.
Okay.
And it listed all the relevant factors, which is, one of the things we look to in abuse of discretion.
Certainly.
So we're looking at specific applications.
Yes, and so, turning to the first of those specific applications, that is C2H, that is with the factors all being laid out in C2, the trial court concluded there was argument raised below about this. The trial court, at least implicitly, because it sort of said nothing about this, found that the ability to appreciate, or rather the inability to appreciate the risks and consequences at the time of the offense weighed against either imposing or
Well, did
setting
the court
aside.
say at the time of the offense? I mean, that's kind of the question for me, is at what point are we looking at this factor? Is it at the time of the offense? Is it at the time of either sentencing, if it's a sentencing issue, or is it at the time of the set aside decision, if it's a set aside case?
Sure. Well, Your Honor, the way that this court has interpreted very similar language, I acknowledge it differs very slightly, but has interpreted very similar language under the IRA is at the time of the offense. That is, in this court held, categorically in Bishop that the inability to appreciate the risks and consequences of conduct at the time of the offense weighs in favor there of reducing a sentence, right? And so here we have the factor saying the ability to appreciate the risks and consequences, but in a statute that is animated by similar principles, that is the mitigating factors of use, the inability to appreciate the risks and consequences of conduct is one of what the Supreme Court has referred to, this court has referred to, the council has referred to as the hallmark features of youth. And so it is necessarily looking at the time of the offense. That is, if we look at the legislative history, because this is I acknowledge the statute is ambiguous on its face. It doesn't specify how the court is to weigh this factor. The council in the committee report cited approvingly to the Criminal Justice Coordinating Council report, stating that, quote, neurological development indicates that persons cannot gauge risk, understand consequences fully, or delay gratification until well into their 20s. There are other the committee report is replete with similar references. That is, in saying that that indicate that the inability to appreciate the risks and consequences at the time of the offense weighs in favor of both imposing the sentence under the Youth Act and setting it aside.
So this is written slightly different than it is in IRA. And in Bishop, we tend to describe that similar factor as being something more akin to a one-way ratchet. Do you think it's a one-way ratchet here, or are there circumstances where someone's lack of appreciation for the risk and consequences could become a negative?
Your Honor, I do think it is a one-way ratchet here. That is for the same reason. That is that both the Supreme Court, this court have described the inability to appreciate risk and consequences as this stage of juvenile or even adult brain development, that is a mitigating factor of youth. It's sort of.
So in a sense, is it rewarding criminality? Like, is there ever a point, and I'm sorry, that's an overly vague question, is there ever a point where I've had such repeat behavior that the trial court could just look at it and say, you know what, that's willful. They're choosing to disregard those consequences. We're not fully convinced that they're really unaware of them. Or
Your Honor, I think there are other factors in Your Honor's hypothetical that would weigh against setting or either imposing or setting aside the conviction under the Youth Act, such as, the fact that the person had already been sentenced under the Youth Act before, right? That's a permissible consideration under the statute, but I don't think that there is, regarding at the time of the offense, I don't think there is any reading in which the counsel could have reasonably been seen to suggest that the inability to appreciate the risk and the consequences at the time of the offense weighs against either imposing or setting aside a conviction.
But there's two questions. There's one, if the trial court says, yes, there was an inability, and so which way does that cut for this particular defendant? There's a second question, which is, did this defendant have the inability or the ability? Right, so those are two separate questions. I agree, if the court says unable, then perhaps that's a one-way ratchet. But what if the court's able to, what about the YRA language says that a court cannot say, with this particular defendant, you know, I mean, suppose there was a defendant who, before he shot somebody, there's evidence that an older mentor near him said, don't do this, don't do it, you're gonna get in big trouble and this, you're ending a life. And they did it anyway. You're saying a court can't take that into consideration?
Not under this factor, Your Honor. That is, that under the ability to appreciate the risks and consequences. And frankly, even under the hypothetical, I think that would suggest that the person in Your Honor's hypothetical does not have the ability to appreciate those. So the fact that, you know, somebody is an older mentor is saying, don't do this thing, and then the person does it. Again, I understand, I think, you know, what's animating the court's concern, but I don't think there's a circumstance in which the trial court could permissibly weigh the inability against the person.
Well, you've lost me. Are you saying that this is a generic thing, that anybody who falls within this age spectrum is presumed to be unable?
So yes is the short answer to the question, Your Honor. That is, I mean, if we look at the committee report in passing this legislation, it is
Then does factor A become superfluous? Superfluous.
sorry, factor 8, we
Factor
have
A,
C2H.
age.
Yeah, excuse me. Well, no, it doesn't become superfluous, Your Honor. It becomes a one-way ratchet, right? That is just like in Bishop that this court held that the first clause of C10 weighs categorically
Well,
in
that's
favor.
A, but we're talking about H, and it sounds like you now have
Well,
H
but
doing
wait,
A's work.
I'm sorry, if I may. C10 under IRA, and I know that we say it's a one-way right, but if you look at the language under IRA, it does speak generally about the diminished culpability of juveniles and persons under age 25, blah, blah, blah. And then it says, as part of that same factor to be considered, and the defendant's personal circumstances that support an aging out of crime. In other words, kind of sets the framework, but then looks at a more individualized assessment.
Well, so what this court held in Bishop, Your Honor, was that the first clause
The first
was
clause.
categorically in favor.
I
And
understand.
that then permissibly the court can consider personal the council did not I see Your Honor has something, a question for me, so I will stop.
I just want to follow on. So now going back to the YRA, what we're looking at now, since here, the language itself does not say as of when the court must consider, quote, the ability. Would it be appropriate and maybe preferable for a trial court to look individually at what the particular person's, the movement important to the court, what their situation was at the time of committing the offense, and at the time the person is before the court? In other words, does this case fit specifically, individually, within this construct of this so-called maturity gap, right? That you are very immature and irresponsible when you're younger, and you slowly age out of that. I mean, now the judge was dealing with someone in their mid-20s, right?
So, Your Honor, looking at the legislative history, I think the answer is no. I think there are other factors in which the court could consider some of the same things Your Honor is saying. For example, the capacity for rehabilitation, right? Something that is forward-looking. The trial court could permissibly consider, you know, things beyond the mental state at the time of the offense. But I think to read factor H here a different way, that is in terms of requiring an individualized consideration of that, would sort of require, you know, presenting a a neurologist or psychologist in every case, right? That is to say, well, this is how brain development works, right? And at this age, brain is not fully developed. Here's how, the neurological reasons why young people are unable to appreciate the risks and consequences of their conduct. And the council took all of those points as established, right, in amending the Youth Act and including this factor.
So if I'm the trial judge considering motion and I get to this factor, how do I think of it? It's just a reminder? This is just
Yes.
saying, it's a heads up. By the way, Judge, when you're considering whether to grant this relief, remember that people who are YRA eligible get this, I don't know, this kind of thumb on the scale.
Yes, Your Honor.
That's what it is.
Yes, and that's precisely what this court held in Bishop regarding the first factor.
And
Right,
can
but-
you connect that up with the age one, which we haven't spoken about? That all the trial judge said is, with respect to that, is he's eligible.
Yes, Your Honor. Yes, there are other claims of error here. One of them being age, as Your Honor has indicated. And so if we look at the trial court's order, the trial court goes through, and sometimes it says this thing weighs in favor. Sometimes it says this thing weighs against. Regarding age, despite the fact that Mr. Williams at the time of the offenses, particularly in the 2010 case, was 16, almost the youngest he could be, the trial court did not give that any weight. And the way we know that the trial court did not give that any weight is because looking through the order, when the trial court was giving something weight, it said so, right? And so the remand would be proper for the trial court both to give that weight and to evaluate under what I would submit as a correct interpretation of factor H.
So I get all of your arguments, and I know what we said in Bishop. And I get your arguments that the purposes animating both statutes are the same. I'm hung up on the simple fact of the plain language of the two statutes. And I think one of the things that we found controlling in Bishop with respect to IRA is that factor 10 doesn't speak to ability, which is a question, right? There's ability and there's inability. I mean, inability vel non is kind of what the statute seems to say. Factor 10 in IRA just says the court must consider as a factor. It's a little weird to have it as a factor and then just say you just have to apply it, but fine. That's what the council did. The diminished culpability of juveniles and persons under age 25, et cetera, et cetera. It's a given. That's how the statute was written. The YRA is not written the same way. It says the court must consider the ability, which suggests that even if we agree with your argument that it's the ability at the time of the offense, that the court can still consider whether there was such ability or not, right? And I agree with you that if there was inability, that's probably a one-way cut. But I'm not sure the court can't consider whether there was ability or inability in the first instance.
So I guess I want to answer this maybe in reverse order. That is, I do want to make clear that even if sort of under any construction, any construction that the court might give to H, that the trial court abused its discretion here. That is, the trial court found that because Mr. Williams committed offenses at the time he was 16 and then 17, that meant he did not at some unspecified time have the ability to appreciate the risks and consequences, and that weighed in favor. I'm happy to pull the language of the trial court's order here. More specifically, the trial court says.
That also raises something that perhaps in the answer you could hit on for us that I think we're all interested in. Whether the trial court needed to consider these things sequentially, the 2010 and the 2011 as separate things, separate motions, or whether this seeming combined consideration was appropriate.
Sure. So I think there are factors that I want to come back to the question, but there are factors that the court could permissibly consider in a combined way. For example, evidence of Mr. Williams' rehabilitation later, right? That is his post-incarceration evidence of rehabilitation. I think there are factors that the court could consider in a combined way, but and there are several factors where I think the analysis is very similar, properly very similar, but I think there are other factors for which it does differ, and some of those are differentiated.
What
in
the,
the brief.
what the court said, to sort of answer for you,
Thank
is,
you, Your Honor.
seriously calls into question defendant's ability to appreciate the risks of or genuinely accept responsibility for his conduct, therefore cuts against the defendant, which I have to say I find a little odd because the court seemed to be doing both at the same time, which is looking at ability to appreciate the risks at the time of committing the offense and current ability to accept responsibility. I'm not really sure what in factor H speaks about acceptance of responsibility. I mean, I get your argument that however we look at factor H, there seemed to be some level of confusion here by the trial court, but anyway. it's not
Sure,
really a
Your Honor.
question.
And just to add that one way the trial court appeared to be doing that was to say that because Mr. Williams committed offenses in 2011, that means that he did not in 2011 appreciate the risks and consequences of his conduct because he had committed an offense before. That's one way that the trial court's order could be interpreted in, but I agree that the acceptance of responsibility is not germane to this factor, and that again, sort of under any construction, the trial court abused its discretion. But
Would you agree, though, that if we accept that, and I know you don't, but if we accept that the court can look at ability or not, and it's looking at it at the time of the offense, that and we agree with you that inability always cuts in favor of the defendant, so you're with me so far, that the court could then say in 2011, you had to have had the ability to appreciate the risks and consequences of your acts because you had already committed this and been convicted. And that cuts against you.
no, I don't think that would be, I think that would be an abuse of discretion. And Mr. Williams, for the same reasons that at when he was 16, that is, that his brain was not fully developed, he couldn't appreciate the risks and consequences. The fact that he did it again sort of only reinforces that he didn't have the ability to appreciate the risks and consequences, or else he wouldn't have done it again,
Okay,
right?
so I mean, this just underscores Judge Ruiz's point, which is that this is kind of a throwaway factor. It's always, I mean.
Well, I take Your Honor's point, but again, you know, this court held in Bishop that it's a little bit odd, right? But it's not that it is superfluous. It's just that something that it always weighs in favor. And if we look at the council's intent in amending the statute in 2018, all of the ways in which the council was expanding eligibility, I don't think it's at all an odd result that there would be one of 13 factors that is always the thumb on the scale.
But under your analysis, it's 2 of 13 factors, right? Age and H.
So age, Your Honor, I think I view A, that is the factor for age, slightly differently. That is, and I don't think that age always has to weigh in favor. I think it would be strange for it to permissibly weigh against, given that the function of the statute. But here the argument was that because Mr. Williams was at the bottom of the range, that is, right, he was 16 and then 17, that the factor had to at least somewhat weigh in his favor, and the trial court gave that no weight here. And so it's less.
So why would that be any different under H if it's based on that science that as someone ages, getting closer to the age of 25, they have more capability to understand things? Why should we not view that, even if it was a one-way ratchet, as one that ratchets down the older the person is at the time of offense?
And sorry, I just want to make sure you're saying that the factor A would sort of weigh less against as the defendant's age increases. Is that there?
That's what I understood from your answer, and I was
Yes.
saying, why would it be any different with H then,
Sure.
based on that science you quoted?
Sure. I don't want to sort of repeat myself, right? But the council in the committee report took all of these scientific principles regarding brain development as true and as applying to people within this age range.
And so under
The
that
argument
science, the
here,
closer you get to 25, the more capability, the more ability you have.
correct.
And so this factor, it's a one-way ratchet, but it has degrees. I mean,
Yeah.
I'm seeing like just A and H keep looking the same to me.
Sure. Well, I don't think A could ever permissibly weigh against setting aside or imposing a sentence under the YRA, but I do think it could weigh. There are degrees, and the trial court could exercise its discretion. And the argument here is the trial court gave it no weight, right? That is, despite his age being 16 and 17.
But I don't know if you've answered Judge Howard's question, which is why wouldn't that same logic apply to factor H, especially with the language in the factor that says the ability, not just the same language that's in the IRA factor 10.
Sure. I mean, I agree that that there, as I've indicated before, that the language differs slightly in IRA and in this statute. And you know, because the claim of error that was raised here regarding age, right, was about the failure to consider it all. Frankly, the proper construction of that wasn't briefed here, so I'm a little bit maybe out beyond my skis here, but that's my read of it. But here the trial court gave it no weight, so I don't think the court necessarily needs to address that is the whether and to what extent age must always be considered, if at all, in favor of imposing or setting aside the sentence under the YRA.
But I thought we were talking about the extent to which the ability argument or inability is less weighty in favor of the movement as the movement is older, still covered, but older. Could the judge say, yeah, I understand you're eligible, you're within the age range, but you know, you're almost 25.
I think a judge could permissibly give the factor less weight in favor, but I don't think it's something it could ever weigh against, right? And here what we have is somebody that's at the bottom of the age range, right? And the trial
I mean,
court.
we're dealing with this question, to what extent are these
Yes.
things generic or
Yes.
are they individualized?
Yes.
And the statute doesn't really, I mean, sometimes it suggests that it's a specific inquiry. And sometimes we just don't know. Right.
We don't through drafting, I agree, Your Honor. But so I don't think in order to resolve this case that the court needs to determine whether it is sort of a uniform, the factor H, that is a uniform application of, you know, 1 point in favor, you know, half a point in favor, right? If we're using something like that. But what the trial court did here was the opposite, right? The trial court found that things that suggested the inability to appreciate the risk and consequences weighed against Mr. Williams in evaluating this factor. I see that my time has long expired. Unless there are further questions.
Further questions?
Yeah, I'm sorry. Can I ask about your view on the TPO issue?
Yes.
Can you clarify whether your argument is that the issuance of a TPO can never be considered under this factor because it's an ex parte proceeding without sort of the ability to present evidence, mitigating evidence? Or is it that the trial court simply didn't set forth enough to justify its reliance on the TPO here without explaining or understanding the nature of the offense that was involved?
The latter, Your Honor. That is, I think that there could be circumstances in which a trial court could permissibly consider facts, whether they arose in the context of an issuance of a TPO or not. Something that, you know, didn't lead to an adjudication could still be relevant to rehabilitation. I mean, I think here, though, what we have is the facts alleged in the petition were that Mr. Williams went to a location that he exchanged some unspecified words, that he called the petitioner to tell her that she was going to be arrested pursuant to warrant, and then she was arrested, right? And that's what was
Right,
alleged
but I
in the
mean,
petition.
a court determined that whatever he did, it was in violation of something he wasn't, I mean, he did something he wasn't supposed to do, right? And so why can't a trial court say, look, you've had another touch with the justice system?
Well, for one thing, Your Honor, and as indicated in the briefs, rehabilitation is about not committing crimes. Mr. Williams was never arrested, right? There was no charges brought. And for the second thing, Your Honor, the affirmative evidence that was presented in this proceeding, in the YRA proceeding, was the petition. There was, while certainly there was the government proffered the existence of a TPO. I think it's pretty divorced to say that we can rely on the fact that there was a TPO, but not a CPO issued to say that even at a probable cause stage that Mr. Williams committed an offense. It's not even alleged in the petition.
No, I mean, so I won't belabor the point, and I know you're well past your time, but then you do seem to be arguing that a TPO can never be considered because it's always going to be that situation, that it's not a CPO, it's a TPO. So it's always going to be what you just said.
No, Your Honor, what I mean to say is that, take out the hypothetical, but where the petition alleges some criminal act, right? That is, the petition here did not allege even a criminal act, right? That is, while I know there is, a general presumption that, trial courts are presumed to follow the law, I think that giving this ex parte TPO any weight where there's nothing in the petition even alleging a criminal act. It would be one thing if there was a criminal act alleged, right? And then the trial court issued the TPO on that basis. I think still we might have an issue where it's an abuse of discretion given the factor here being capacity for rehabilitation and all the other evidence of rehabilitation that was presented. But we don't even have the allegation of a criminal act here, whether it was ex parte or not. Thank you.
All right, we'll reserve a few minutes for you. Mr. Hobel.
Thank you. May it please the court, Mark Hobel for the United States. I'd like to address the issues in the order that Mr. Madsen took them, starting with the standard of review, then the factor in subsection H, and then finally, maybe briefly at the end, touch on the TPO issue. Starting with the standard of review, the standard of review does come from this court's en banc decision in Vini, which stated that an adult sentence may be imposed even for a person who's eligible for a youth act sentence if the record reflects that the sentencing judge was aware of the availability of the act, considered the rehabilitative option, and consciously rejected it. And I want to focus on the considered the option because that is how Vini interacts with the amendments.
The statutory piece that your opposing counsel cited, how do you get around that? And should it matter, and to compound the question, should it matter at all to us that Vini is really about the actual sentencing in the moment and review of a sentence as opposed to this review of a motion which very much pulls in those sentencing factors, but is kind of a separate beast?
Yeah, if I understand your honor's question, forgive me if I misunderstood this, but it does make things a little bit trickier when when a judge is confronting the issue in this case, which is whether, a decade down the road, a youth offender's conviction should be set aside and incorporating factors, as Judge Hertzfeld was directed to do by the statute, factors that were designed for the sentencing piece under the 2018 amendments. But if I could just quickly circle back to the amendments and how they interact with the standard of review under Vini, because Mr. Madsen's claim is that the en banc decision was abrogated by those amendments. In fact, the amendments are entirely consistent with the standard of review announced in Vini. Vini says a judge needs to consider the rehabilitative option. If you look at subsection 24903C2, which is where the additional factors were added, the amendment says, in using its discretion in sentencing a youth offender under this act, the court shall consider, and then lists the series of factors that the court must consider. That language that's added to the statute is entirely consistent with the standard of review from Vini. And here, as my colleague has acknowledged, Judge Hertzfeld did consider all of the factors that she was that she was required to do.
I'm not sure you and your colleague are all that far apart then, really. I mean, it seems to be a quibble over, I mean, something that's not all that consequential. I mean, the statute uses the word discretion, and you would agree that it's reviewable on appeal, right? It's not insulated from review on appeal.
That's correct.
And so
We're not
what-
arguing reviewability.
And so what would be a lower standard than abuse of discretion? I mean, are you saying Vaney establishes a review that's lower than abuse of discretion, and it's simply whether the court even like, did the court completely drop the ball and fail to even consider the motion? I mean, is that the level?
I mean, I think, abuse of discretion can be a coat of many colors. It can apply differently in different circumstances, and the way it applies in the YRA context is dictated by this court's en banc decision in Vaney, which is, this is sentencing discretion, and a trial court is at the apex of its discretion when it's engaging in a sentencing process. So, in this case, it was sufficient under Vaney for the court to say, to recognize its discretion, that it had discretion to set aside the convictions, which it did, to consider all the factors it was required to consider under the amended YRA, the Youth Act, which it did, and then to consciously reject the option of set aside.
But you would agree, I mean, the statute requires a writing that goes through all the factors, right?
Yes.
And so would you agree that if the court went through a specific factor, I've got to pull them up, but, and just, completely flubbed it. And I mean, obviously, Mr. Mattson's saying that happened here, but we don't have to get into that yet.
Yeah.
Let's say the youth offender's age at the time of the offense, the court says the offender was 27 and the offender was clearly 18 when it happened, just completely drop it. That's not an abuse of discretion.
So I think it is consistent with the review that in Vaney and in Dorzinski, which is the Supreme Court case, to review procedural claims, such as if a trial court is required under the statute to consider a factor and it doesn't consider the factor, it's not engaging in the consideration that it's required to do that.
Yeah, but I'm saying just gets it wrong, just completely misreads the fact. It considered it, but it just completely misreads the statute. And here there are some close questions on whether a court misread a factor.
Right.
And we're gonna get into that next, I guess. But let's say there's one where everyone agrees the court misread the factor.
Right.
I mean,
Yeah.
you're saying that's unreviewable effectively?
No, I think that's consistent with Vaney and Dorzinski to review a legal error. I think both Vaney and Dorzinski, the Supreme Court case that relied on, decided a legal question antecedent to articulating the standard of review. And the legal question in those cases was effectively, did there need to be an explicit no benefit finding under first the Federal Youth Corrections Act and then the prior version, I guess, of the Youth Act.
But
So
it's
a legal.
clear that now that under the amendments, a trial court has to do more than the trial court had to do at the time Vaney was decided, right?
A trial court does need to consider more factors. I agree with
It
that.
has to write them out,
Right.
explain it in writing. I mean, there's clearly
Yes.
a tightening of the
Yeah.
requirements of
Yeah.
what the
Yeah.
trial court has to not just do, but show that it has done,
Oh, sorry.
right?
Mhm.
And again, it gets to, it was, in other words, we now have more of a record to review than was the case at the time Vaney was decided. So why wouldn't we now apply our long established, much cherished abuse of discretion standard as laid out in the Johnson case written by Judge Newman, which is,
Yeah.
what we usually do. Did the trial judge recognize it had discretion? Did it go through the proper factors? But also, were they reasonably applied? I mean, it's not a completely hands-off review.
I don't think, if memory serves, I don't think that Johnson was dealing with a sentencing issue. I think that this court's long established approach to sentencing discretion is a little more fulsome than the abuse of discretion review that was discussed in Johnson. I happen to think, by the way, that if this, and this goes to maybe how consequential this issue is, I do happen to think that if we just look back to Johnson for how abuse of discretion works, I would argue that Judge Hertzfeld did not abuse her discretion here. And, I'm happy to turn to subsection H. So I'm ultimately not sure how much of a difference this.
Let's talk about H, because
Sure.
that's clearly the kind of
Yeah.
at the center of this, which is, given what we know about what was motivating the council, how can inability to whatever, appreciate the consequences, et cetera, cut against the movement?
Right. So the place to begin, I think, is the distinction between subsection H and the sort of analogous provision in the IRA as interpreted by the Bishop case. The IRA, and these provisions are written differently. The IRA provision is categorical. It's not individualized. Subsection H is clearly individualized. It says the youth offender's ability to appreciate the risks and consequences of the youth offender's conduct. It's clear, and I don't necessarily think that, I'm not sure that Mr. Madsen is saying that this is not individualized. I take his point to be, this is a one-way ratchet. In other words, that the trial judge couldn't consider it against the defendant. But as he's acknowledged in his brief, this court in Copeland interpreted using the new amended statute, applied this factor and found that a defendant who did not accept responsibility, did not display remorse at sentencing, was this factor could reasonably weigh against that
Were we
defendant.
really looking at that question in Copeland, or were we just assuming unchallenged facts?
Yeah, that was Mr. Madsen and myself again. So I think the focus in Copeland was more on a discovery issue. But look, I mean, the issue in Copeland was whether the judge there had abused, the court there had abused its discretion in denying YRA sentencing, and the focus there was on this particular factor. So, was the categorical argument made? I don't believe it was, but was the judicial mind turned to this factor and its application and whether it could apply against the defendant? I would submit that it was. So Copeland is at the very least persuasive on this question, and it cuts against the argument that's made here by, the argument that's made here in a couple of ways. First, the point that I think Williams is trying to make is that this can only apply. This has to be looked at at the time of the offense rather than at the time of sentencing. Copeland looked at this factor at the time of sentencing relative to a defendant's ability to appreciate the risks and consequences of sentencing. Second, of course, it held it against a defendant's failure to appreciate the risks and consequences of her actions, held it against her. So that's two ways that Copeland cuts against the argument about subsection H that's being made here. I note too at the point that it has to be at the time of the offense. Other factors, and I direct the court's attention to subsection A. I direct the court's attention to.
Sorry, counsel, I don't mean to interrupt you.
No,
but-
please.
Well, I
Yeah.
do. But I apologize for interrupting.
Yeah.
But I'm a little confused how the language of, look, I tend to agree with you. The language is different in the YRA from IRA, and the IRA seems more categorical. This speaks of ability versus inability. But I'm a little skeptical about the point at which it's supposed to be judged, because if you're talking about the point of sentencing or set aside, it doesn't really make much sense to speak of the ability to appreciate the risks of actions that occurred years earlier. I mean, it seems to speak to at the time the offender is about to engage in the conduct, are they able to appreciate the risks and consequences of what they're about to do? I mean, how does it make sense? The trial court and your brief seems to treat this as sort of an acceptance of responsibility analysis, and I don't see that anywhere in the language of the factor.
Right, well, I think that one of the complexities here is the fact that the court is in deciding set aside and applying these factors years down the line from the offense. There isn't a lot of clear guidance from this factor as to whether the court should be looking at the time of the offense, at the time of sentencing. I think, and I apologize if I'm misunderstanding your question, but I think this is what it's going to, that it seems like it would be reasonable maybe for the court to have said, standing here right now, do you appreciate the risks and consequences, the risks and consequences of your conduct rather than at the time of the offense? I understand that argument. I just don't think that's the argument that Mr. Madsen is making today. His argument is that this has to be at the time of the offense. So in that respect, at least, he's not arguing that the sentencing judge abused her discretion in considering whether at the time of the offense Williams could appreciate.
Well, no, I mean, I think his argument is twofold, because the trial court's statement was twofold. I mean, the trial court said, I think you did not have the ability to appreciate the risks of your conduct. And I think you are not accepting responsibility for your conduct. Therefore, this weighs against you. And it seemed to be a mishmash of two different concepts. The latter, at least, of which I don't see in the statute. This notion of standing here before me now, do you accept responsibility for your conduct? I mean, that question seems to be subsumed in some of the other factors, like perhaps the ability, to be rehabilitated, but not this notion of of one's ability to appreciate the risks of their conduct.
Mhm.
I
Yeah,
didn't have the question at the end of that, but
Yeah, I think this gets to maybe to loop back to the first point about the standard review. This gets to the difficulty of the appellate sort of reweighing of these factors that Vini counseled against, really held against, because fundamentally, I think Judge Hertzfeld was bothered by the fact that Williams got a YRA sentence in the first conviction, and pretty immediately on supervised release committed a strikingly similar new armed robbery. And that from Judge Hertzfeld's perspective, whether you think about this as a appreciating the risks and consequences, as the nature of the offense, as a general set point in sentencing discretion, that he's not a deserving candidate for YRA relief when he had an opportunity. And he really displayed that this was that this was not something he would benefit from. I realize that there's another way to look at this, which is that he was young and that he had a difficult time appreciating the risks and consequences. I'm not here to argue that if a judge had weighed this in his favor, and said, he was young then, he's older now, that would be an abuse of discretion. Absolutely not. This just goes to the range of sentencing discretion that a sentencing judge has to put all these pieces together and make a call. And that's what Judge Hertzfeld did here. So I just,
I mean, I'm guessing your answer to this question is going to be, it depends on which way we go. But don't you think that we should at least clarify this, because it does seem like the trial court was confused about what this factor means. And it seems like it seems to read a little ambiguously to me.
right. And to the extent, I'm not sure I agree that's necessary, but to the extent that the court does want to clarify it, I think that any clarification should certainly be consistent with Copeland, in which a defendant who expresses no acceptance of responsibility, no remorse at trial and sentencing, this factor can be weighed against them. I think it's also the case, and I think, Judge Schenker, you had asked a hypothetical about a defendant who is about to commit a crime and an older mentor says, don't do it, and he does it anyway. my understanding of Mr. Madsen's point here is that that would have to weigh in the defendant's favor. I don't think that can plausibly true. Because I think, the flip side of that is unfair to the people who try, who demonstrate some restraint, who demonstrate some acceptance of responsibility and remorse, and are penalized for maturity and for, because look, teenagers, young adults have their lucid and mature moments too. It's not all just a one-way ratchet here. So
Well, the
I,
defendant who exercised restraint in that situation would never be before us, right?
hopefully not, no.
I mean, they
yeah,
wouldn't have
yeah.
committed the crime, so.
Right. But I do think that if the court is going to interpret this factor and provide additional guidance, it should be consistent with the general broad sentencing discretion that trial judges have, and that I think that at least with respect to the amendments is throughout the committee report on the amendments, it's clear from the legislative intent here that the court, although it did provide the council, although it did provide additional guideposts, also reemphasized that a judge's discretion is important. That's why the council, another thing it did in these amendments is it clarified that judges could go below the mandatory minimum for qualifying youth offenders. That's discretion enhancing. And so any, if the court wants to, if the court wants to clarify the timing issue here and whether in the particular context of a set aside, should the judge be looking at, the time of the set aside, the time of the offense, I understand that impulse. I just would counsel would ask the court, consistent with the amendments and consistent with, I think, Vini and this court's other decisions on this, that any interpretation reify the traditional discretion of sentencing judges and not hamstring them in their ability to make choices about individual defendants. I'm happy to just briefly address the TPO issue. I realize I'm out of time. I'm not sure at this point how much disagreement there is between us, because as a categorical matter, Mr. Madsen is not suggesting that, as I understand his argument, as a categorical matter, the TPOs can't be considered. The judge, it was reasonable for the judge to exercise her discretion, consider the fact of the TPO, rather than kind of look under the hood and effectively have a mini trial as to the allegations in the TPO. At the end of the day, a judge here did make a determination, made a finding against Williams. And the judge, there's no indication the judge didn't understand what a TPO was, didn't give it appropriate weight. It's clear that fundamentally the most important factor for Judge Hertzfeld was the second offense so close in time after he'd originally received a YRA sentence.
Yeah, but it sounds like the TPO. I mean, the judge does mention the TPO and mentions, the repeat and then the more recent. It does seem to make a difference to the judge, especially given the factor that she was considering it under. And no, you don't need to hold a mini trial, but you can at least look at what the allegations were, right? And what happened. Was there a CPO? Was
Right.
it?
But then, my understanding is there was not a CPO.
Right.
And there's no indication that she considered. I would think that if there had been a CPO or there had been a case, that the criminal case that arose out of it, that would have been entitled to, and she would have given that more weight. She gave I do think, however, that in the context of the Youth Act, there's a somewhat important and nuanced point to make, which is that in seeking a set aside, Williams is seeking to hide his conviction, to erase the evidence of his conviction. I don't mean to put that as, I realize I just used some somewhat sinister language. I didn't mean to do that. But to effectively take it off the books. So potential romantic partners are not going to be aware of that background that he has. And he's entitled to a chance to argue to a court that he should be given a set aside. But the fact that there is now this DV history even if just a TPO, is a factor that the court can consider in deciding whether, in effect, ordinary people who are going to interact with Williams are not going to know that he's been convicted of these 2 armed robberies. This factor she could consider, and she reasonably considered it. So again, at the end of the day, we believe whether under Vini, whether under abuse of discretion, per Johnson, this court should affirm the trial court.
Can you address the issue that Mr. Madsen raised about that? To the extent to which a trial judge should have considered the motion to set aside the 2010 convictions separately from the motion to set aside the 2011 convictions because the factors did not apply exactly the same as to both. She seemed to mush them together.
So I think that, and I apologize, I don't have her ruling directly in front of me, but at some point in her ruling, she does say, I'm treating these together because they're mostly intertwined and they're intersecting issues, which is correct and reasonable. So she recognized that they weren't exactly the same. And if you look at her discussion of the factors, she said, as to, the first conviction, he hadn't received the YRA treatment before. As to the second, he had. So she did differentiate them, but I don't.
In a factual way, but not in the final, in considering them.
Right.
I guess a point that I guess like Mr. Madsen's speaking for him would be maybe there might be a case where you say, I'm going to set aside the 2010, but not the 2011. I don't know what that leaves him in a practical sense, but
Yeah.
that might have been the more proper
Yeah.
way of addressing this.
Yeah, if memory serves, and Mr. Madsen can correct me if I'm wrong, but I don't think that that Williams in the proceedings below really said, look, I'll take I'll take this 2010, even if you're not willing to set aside the 2011 or vice versa. I also don't think it would have necessarily been unreasonable for a judge to have taken that route. I just don't think it was unreasonable for Judge Hertzfeld to treat these 2 very similar convictions occurring very close in time together as consistent, especially when, the appeal that Williams was making was, look, it is harder for me to get, work if with these criminal convictions on my record. And I'm just not sure whether one armed robbery conviction is better than 2. I guess I understand that, but I don't think he emphasized that point. I don't think it was unreasonable for her to.
No, and I understand that she viewed them together because she thought that in a sense, and then we go back to this ability or inability to appreciate that the second offense after having gotten a break and in being charged and kind of having been faced with the consequences of his actions, she counted that against him. And which goes back to this question, how is that supposed to work under this statute? Is it just a showing of how totally unable he was to appreciate the consequences?
Yeah, I mean, I think this does go back in a sense to why why Vini came out the way it did with respect to the standard of review. That is, these are tough, nuanced questions, fact-intensive questions, and there is a process in place that the council has dictated to trial judges to consider. The judge here followed that process. She did everything she was required to do under the statute. She made a reasoned decision, and the fact that another judge might have come out differently, no doubt about that, but that's not an abuse of discretion.
I understand abuse of discretion. We know different judges can come out differently. And sometimes that's a good thing because it means that there's more individualized and they're different human beings, but it's not necessarily a super positive feature of our system that if you take exactly the same case and present it to 2 different judges, you would come out different ways. It's not something we want to hold out as a feature.
Yeah.
But when it turns on something as critical as whether the inability to appreciate consequences cuts for or against, that is something I think this court has to give guidance to the trial court to say, no, everybody, this is the way you need to look at this factor. I
disagree with the final specific point at the end, which is that I don't see it as necessary for this court to give guidance on how everybody should be treated. Everybody should be treated under this fact. I think that is inconsistent with the statutory structure, which does, whether you consider it a feature, a bug of the system, that sentencing judges have a lot of discretion and that individual sentencing determinations can vary quite a bit. That whether it's a feature or a bug, it's baked into the Youth Act, and it is a feature. I'll call it a feature. It is a feature that the amendments again reified and didn't dispense with that. They gave a little more guidance, a little more guideposts to cabin that discretion maybe a little bit, but it's not like the council said, look, there's no indication that the council said, look, sentencing judges before weren't subject to particularly probing review by the appellate courts. Now they are. There's no indication that the council was intending to abrogate or change the appellate standard of review. If you look at the committee or the lengthy committee report on this legislation, which says a lot of things, one thing it does not say at all is Vini. One thing it does not address at all is the appellate standard of review. And it used the same word from Vini, consider the option. It added that in the statute itself. In it, the judge in its discretion must consider these additional factors. It's consideration.
Having considered it, and okay, in your opinion, can a trial judge say, I'm considering this factor, I think you were unable to appreciate the consequences of your acts. I hold that against you. That counts against you. Consistent with YRA?
Yes, I think that's what happened in Copeland, is that a judge did hold that against the defendant who was, in that case, it was a sentencing, but it wasn't, I think it was maybe a year or so after the offense itself that the sentencing occurred in Copeland. And the judge did hold that against the defendant, and this court said, and admittedly on a slightly different set of issues it was thinking about, but it said there was no abuse of discretion in doing that. And there's no indication, going back to the guidance point, I'm sorry, I realize my time is up here. There's no indication that somehow this trial courts are jumping the rails here. There are quibbles that can be had, and there are criticisms that can be had, I'm sure, of Judge Hertzfeld's determination here. But at the end of the day, not even Mr. Madsen is arguing, as I understand it, that she had to grant him set aside. This is pure procedure. And it's not clear to me that it would make any difference, or that Williams didn't get a fair hearing here, or that, and certainly not that the judge didn't follow the statute reasonably. So again, we would ask this court to affirm. Thank you.
Thank you. Mr. Madsen, you've got a few minutes.
Thank you. So a few things. The government it's a little bit difficult to tell what the government's position is to your question, Judge Ruiz, regarding whether this is abuse of discretion or something else. It's sort of initially the government's answer seemed to be, well, no, this is abuse of discretion, and then they sort of fell back to Vini again, which is something less than abuse of discretion. And if you look at pages 6 to 7 of the government's motion for summary of affirmance, ultimately treated as its brief, they are explicitly arguing for something less than abuse of discretion. And the government says this is hard, sentencing decisions are difficult. Well, that's certainly true, but the same is equally true of decisions under the IRA, where this court is considering whether to reduce the sentence. And so it would be sort of strange if where the council had created these two statutory schemes motivated by the same principles, for someone to have more appellate rights regarding a potential resentencing than they would have the sentencing in the first instance, the decision whether to sentence someone under the Youth Act. The government talked, and sorry, so just to be clear, certainly my position is that Vini has been abrogated. One point I didn't get to when I was first up here is that one of the other reason underlying the court's decision in Vini for only requiring that acknowledgement that the trial court was aware of its discretion was that there were no statutory factors guiding the court's decision at the time. And obviously we have a very different situation here. Judge Ruiz, you also inquired about the possibility of different judges reaching different conclusions. And I think in the committee report at page 21, the council was concerned about the same thing in terms of getting to the point of whether this court should review for abuse of discretion or something less. Quote, it is unclear why some young adults have been sentenced under the YRA and some have not, right? So the council is getting at this concern that trial courts are not doing this equally, and that's sort of throughout the report. Judge Shanker, to turn back to your question for a minute regarding the TPO, I think the best way to say it here is that the trial court abused its discretion because it lacked a firm factual foundation for concluding that any of those facts that had been there in any way related to rehabilitation. The government also argued regarding why at the time of the offense regarding C2H. I want to note that when amending the statute, one of the other changes that the council made was determining eligibility based on age at the time of the offense. So, you know, that certainly the council, when it was thinking about what is the time that matters here, it is thinking about at the time of the offense. The government also argued that the construction that Mr. Williams is advancing here of C2H would penalize people younger people who had an ability and exercise that ability to appreciate the risks and the consequences. And I think in addition to the point you raised, Judge Shanker, that they wouldn't be before the court if they did that. If the factor is weighed categorically, it is not unfairly penalizing anyone. That is, if it is a one-way ratchet, right? It is not disadvantaging someone who, you know, a young person who may have had happen to have more ability. And just to briefly address Copeland, this question was not presented. The proper construction of C2H was not presented in Copeland. It lurked in the record. That is the argument that was advanced, as both Mr. Hobel and I are very aware, was that the trial court had abused its discretion by relying on certain facts to conclude that Ms. Copeland lacked the ability to appreciate the risk and consequences at the time of sentencing. The construction of the statute was assumed. In hindsight, I think that, you know, my error there, right, in raising it there, but certainly it was not, the proper construction of C2H was not addressed in Copeland, and stare decisis is never properly invoked unless the court is expressly addressing the question presented. I see that my time on rebuttal has expired. So for all the reasons indicated, what I'm asking is for the court to remand for further consideration under correct legal principles. Thank you.
Thank you to both counsel. The case is submitted. All right, we will next hear 23 CV 1046 BDO USA PC v. Gia Sabota.
Thank you, Your Honors. Good morning. My name is Michael Kimberly. I represent the appellants, BDO in this case. Your Honors, there are two issues that are presented in this appeal, broadly speaking, at least.
Counsel, with apologies for interrupting you so soon, would you like to reserve any time for?
Oh, yes, please. I'm sorry, Your Honor. May I reserve 4 minutes? Please? Thank you. So broadly speaking, two issues in the case. The first is whether the principal basis on which the trial court here ruled that the arbitration provision does not apply is correct or incorrect. And then the second is, if we are right that the arbitration provision does apply, what is the appropriate course moving forward? And I'll start with the first issue. I think really what this first question boils down to is what the words or otherwise mean in the first sentence of section 14.7. And that provision specifies, quote, any controversy or dispute relating to this agreement or the partnership in its affairs, or otherwise arising between a partner and the partnership, ellipses, shall be resolved and disposed of in accordance with this section. Now, I would not have thought that the words or otherwise were especially challenging to understand in this context. They indicate alternative conditions. If you fall under the first condition, if it's any controversy or dispute relating to this agreement or the partnership in its affairs, then it's subject to arbitration. If it isn't that kind of disagreement, but it is instead a disagreement, quote, arising between a partner and the partnership, that also falls under the plain terms. of
Well,
the
I mean, the
arbitration.
reason it's confusing is because the fact is the contract does use the word otherwise. And under your reading, it wouldn't have to use the word otherwise, right?
Well, I don't think that's true, Your Honor. I'd point the court, for instance, to Visconti's will. This is 119 Northeast Second 34 at 36. This is a New York Supreme Court, New York Court of Appeals, highest state court decision. And it says that, quote, the words or otherwise represent terms of enlargement to include every conceivable situation outside those stated. So it's just specifying that when, by using the words otherwise, the provision means any controversy or dispute relating to the agreement or the partnership or its affairs, or any other conceivable.
Right, but
kind of
I guess what
dispute.
I'm saying is, I mean, we can argue and we will. Or you and your colleague will argue over the meaning of otherwise or the lack of meaning of otherwise. But it seems like your position is that you could take out otherwise here, right? I mean, that's the meaning of the provision that you're ascribing to it, is just delete otherwise, because or arising between a partner and the partnership would cover what you seem to say the provision means,
I mean,
right?
Your Honor, I think otherwise is doing work here. I think it's emphasizing, as Visconti's will suggests, that this is a term of enlargement, that it is not meant to be limited in, and that the second condition, the second contractual condition, is not meant to be limited in any way. I'd point the court as well to 22 New York jurisprudence section, section 240 cited in our brief, which makes clear that the use of a disjunction or, as opposed to and, a conjunction in a contract like this suggests alternative conditions.
But you would agree that at least colloquially, otherwise can be read as similarly, right? So it seems to say here, relating to this agreement or the partnership and its affairs, or similarly arising between a partner and the partnership.
I don't think that's true at all. I would not use the word otherwise as a synonym for consistent. In fact, matter of Reefberg's estate, 1983 New York Court of Appeals case says that the word otherwise means different from, the exact opposite of similar to. And I think that's the way that most people would understand otherwise. Otherwise is in contradistinction to, apart from what has been already said, everything else is what it means. And I would add, Your Honor, if the court is concerned about interpreting language in the contract to lack operation, it's certainly the superior court's approach that renders more of the contract inoperative. The provision would mean precisely the same if the words any controversy or dispute relating to this agreement or the partnership and its affairs were completely stricken from the contract. It would be enough just to say any controversy or dispute arising between a partner and a partnership is subject to the agreed dispute resolution procedures of this clause.
I mean, you seem to suggest in your brief that otherwise arising between a partner and a partnership would cover perhaps a situation where a partner slipped and fell.
That's right. It's any disagreement between a partner and the partnership that isn't about the partnership or the partnership agreement.
And then, so what would you say about, so then you would say that that's meant to cover where a partner slips and falls, but to make clear, I guess, at least through negative implication, that it would not cover, that the entirety of the phrase means that it would not cover where a third party slips and falls
Exactly.
in the building.
That's correct.
Because that would neither relate to the agreement or the partnership or be between a partner and a partner.
That's correct.
Sure.
That's correct. And in comparison, what the first clause means by not limiting it to between a partner and a partnership, between the partner and the partnership makes clear is that it doesn't matter whether one of the parties is no longer a partner or a part of the partnership. If the nature of the controversy, if the, common nucleus of operative facts, if what the case is about arises out of or relates to the partnership agreement. So
But
that
you
would necessarily
specifically
enforce it for
define
former
in
partner.
section 14 the term former partner as opposed to partner. And when you have a specific term, why should we just read it in when you haven't written it?
That is not what we're asking, Your Honor. Our position is that the phrase arising between a partner and the partnership has nothing to do with this case. You don't have to interpret that at all. It's enough just to say that this case, which is about a breach of the partnership agreement and an alleged breach of fiduciary duties relating to the partnership that it creates, is a controversy or dispute relating to this agreement or the partnership and its affairs. That's all we have to show. We don't have to show that it arises between a partner and the partnership because that is a disjunctive alternative condition.
Right. But the alternative argument would be that that second part, the post other or otherwise,
Mhm.
covers former partners, right?
I suppose if,
I mean, that would be another argument that would sweep this dispute under the arbitration clause.
I think it's fair to say if the court read the word partner in the second alternative condition to
As
include former
including-
partners,
right.
yes, that also would have covered this dispute.
But you're not making that, you're
I'm not
saying,
making that argument.
You're not making, you don't
Not
think the
making that
14.5
No.
applies to you.
No, because it's a disjunction. And as New York, the many New York cases that we cited make clear, a disjunction means one or the other. It doesn't mean both. And I think all you have to do is look at, this is page 530 of the appendix, to see how the district court approached interpretation of this provision, to understand that what the district court, what the Superior Court did was rewrite the provision. It adds bracketed material between a partner and a partnership, following the words any controversy or dispute. This is the final sentence in the second full paragraph, right in the middle of page 530. I mean, it is one of the clearest examples of judicial rewriting of a contract provision
so
I
can
think you're
we,
likely to see.
so can we get to the antecedent question of whether the trial court should have reached this in the first place? Which perhaps maybe is where you could have started, but what are the limits to your party presentation argument? So let's say that the arbitration agreement here had buried on page 27 in the middle of a seemingly unrelated paragraph, something that said, I mean, I'm being absurd here, but nothing in this agreement in any way relates to anyone named Eric.
Sure.
And nobody had found that or raised that until the night before the hearing, and some enterprising Superior Court clerk found it.
Yeah.
Could a trial court not say, hey, we need to talk about this tomorrow, and then rely on that provision?
Your Honor, I think it depends a bit on circumstance. In the circumstances presented here, we're 4 years into litigation. We've exchanged numerous briefs addressing the applicability, scope, enforceability of this contract. 18 hours before the hearing overnight, I think the answer is straightforwardly no. And it's the simple rules of waiver. Especially when we're talking about private rights and contracts, we're not talking about interpretation of statutes like the prior case where there are broader public interests at stake. This is a private dispute concerning a private document.
So your answer is, and I'm not
The
poking you on this, your answer is that even in that situation, the court would have to say, I mean, wouldn't necessarily have
Wouldn't
to
say
say
anything.
this, but would just ignore the fact that its reading of the contract suggests that it should not apply, but it would have to ignore that.
Well, that's right. And who's to say why the defendant in that case would choose not to raise the argument? The defendant in that case might have good strategic reasons not to waive the argument. I don't know what they might be. It's, as you say, an unusual hypothetical, but they might be there. And the point is that the role of a court in a case like this is to be a neutral arbiter, to resolve the issues that are presented to it the way that they are briefed to it by competent counsel. And in the entire 4-year history of this case, it has been an accepted premise of the parties' arguments that if this provision is enforceable, it covers the dispute here. And that's, I would submit, because it is, I think, straightforwardly and obviously a controversy or dispute relating to this agreement and the partnership or if its affairs. It alleges a breach of the agreement and it alleges a breach of fiduciary duties
Well,
relating to
plus
the
you have
partnership.
the overlay that in the first appeal, this court asked the trial court to decide the enforceability issue, right? The unconscionability. issue.
That's correct. Which notably the Superior Court declined to do.
Right. Because it
Selecting
went off on
instead-
this- on
Exactly.
This tangent.
Right, so there's an interesting dynamic in this case, I think, about, you know, the mandate rule and refusing to follow the mandate and the remand instructions of this court to address the issues that before this court in the prior appeal also had been the sole issues briefed by the defendant in the case.
So whether we agree with you on that or agree with you on the proper interpretation of whether dispute is covered by the arbitration clause, we'd still now get into this issue that we thought was going to be the focus of the litigation, right? Which was whether the clause is unconscionable or not, and what should happen.
Right, and I would say those are two alternative paths. You might say the court, I'll say I led with the merits, Your Honor, because I just want to make clear, we are not, we think we're very clearly right on the interpretation of the contract. But even if you disagree with us and agree with the Superior Court on the merits of its resolution of this case, and the interpretation of the provision, you'd still have to hold that the issue was waived and it was an improper course to substitute its own pet theory of how to resolve the case. So setting that aside, Your Honor, then the second issue, if the court agrees that the Superior Court should not have resolved the applicability of the provision in the way that it did, I think the question that confronts the court is whether or not the Superior Court should have, under either New York Civil Practice Law and Rules, Section 7504 or Section 5 of the Federal Arbitration Act. And we would say they're effectively coextensive, and I think they both apply, should have appointed a substitute arbitrator. And for 3 reasons, the answer is yes. As a starting point, the method of naming and appointing an arbitrator assuredly has failed. And that's the words of the New York law that the Superior Court concluded apply here. That specifies that if the agreed method of appointment of an arbitrator fails, or for any reason is not followed, the court, on application of a party, shall appoint an arbitrator.
Okay, so if for any reason, do we have to decide, or if we think it's not appropriate for us to do so, would the trial judge on remand have to decide on the alleged, the asserted unconscionability?
No. No,
Because you think it's irrelevant, the reason why
I would,
no arbitrator has been assigned for these clauses to trigger?
so it's one of 2 things. Either it's irrelevant or it's moot. You know, by either path, it's sort of a debate over
The
labels.
mootness being BDO's waiver.
The mootness being BDO's waiver and the fact that BDO no longer has partners under the organizing documents of the company to appoint according to the
But
agreement.
can that whole waiver issue even be kind of skipped by saying it doesn't really matter? There is under the FAA, the New York provision,
Yes,
authority to trigger. I mean, yes, there is a possibility of triggering the court's authority to appoint arbitrators just because what was provided for in the contract is, for whatever reason,
has
not
not been
possible.
followed. Yes, is not possible or has not been followed. I think that's exactly right, Your Honor. I think the easiest way to resolve the section 5 or section 7504 question is simply to say, look, as a matter of fact, the parties have not followed the specified procedure for naming arbitrators in this case. Accordingly, because BDO has in turn applied to the court for application of a substitute arbitrator, the court is statutorily empowered to appoint an arbitrator.
Not just empowered, your argument has to be that it's required, right?
That's right. It's mandatory. That's correct.
Mhm.
And your argument also has to be that the unconscionability of the provision is, I mean, you've already said this, but it just need not be reached.
It need not be reached, and I think the best case on that score, Your Honor, is the Rigoni case, 295 F 3rd 124. This is a Second Circuit case, which says that unconscionability is an equitable defense to enforcement of a contract. And a party can't complain when the plaintiff against whom this defense is being asserted simply agrees to waive the potentially unconscionable provision of the contract to avoid the unconscionability and move forward with otherwise observing the intent in terms of the.
I mean, but that would
agreement.
really only apply if the unconscionability claim is directed at the selection of the arbitrator's provision and not necessarily to the entry into the agreement.
Well,
altogether,
but
right?
under New York law, you have to have both procedural and substantive
Right.
unconscionability. And frankly, the procedural unconscionability issue, which I acknowledge was not reached by the Superior Court, is a pretty easy one. These are sophisticated parties negotiating compensation worth millions of dollars. This is not a contract of adhesion against a consumer. The idea, there were opportunities to negotiate. There were weeks or months with the contract before Mr. Giacomotta had to make a decision whether or not to sign. His salary was being doubled, which is why he signed, because he was getting a great deal. The idea that there was procedural unconscionability here just doesn't stand up. But the court doesn't have to say anything about that because there's clearly, because the substantive unconscionability is limited to the method by which the arbitral panel is selected, and because that now is both waived, hasn't been followed, can't be followed any longer because of the change in structure of the company, it's sort of off the table. And the remedy in cases like Bowers against Gateway 2000 and Phileas, New York law cases, is a resort to Section 5 and the appointment by the court of a substitute arbitrator.
So taking you a little bit off track again, why doesn't that process that we were potentially concerned with and Judge Deal wrote about in his concurrence, why isn't that evidence that unlike the interpretation you're giving us and that you've maintained below, this really was a partnership agreement designed to settle internal disputes and not external ones? Because, it makes sense that we would appoint partners to handle disputes between the partners. And then further, the rest of the language talks about except that the partnership and the partner may seek provisional remedies from a court and any accounting provided for this agreement to be conclusive shall not be subject to this procedure, et cetera and so forth. Everything seems to, at least at a cursory glance, and on review, look like this really is about internal partnership disputes and not really former partner issues.
So, Your Honor, we are here in this suit, started 4 years ago, still haven't gotten to the merits, still just arguing about arbitration, have been attempting to enforce Section 14.5, the partnership agreement. Section 14.5 is necessarily about former partners. It's about what partners who depart the partnership are permitted and not permitted to do. The arbitration provision, in turn, makes clear that it concerns enforcement of the agreement. So this provision of the agreement necessarily implicates former partners, and the arbitration provision says breaches of this agreement must be arbitrated. So
But then but then do you agree? And I suppose your answer is I don't have to answer that question, so I won't. But wouldn't you agree then that it's an odd situation? Put aside contract interpretation. It's an odd situation to say that current partners who are directly impacted by the outcome of the arbitration can sit as the arbitrators over a former partner.
Yeah, Your Honor, I am pleased not to have to be defending the merits of that provision. I think we've got good arguments. We pointed out that every other court to resolve it has upheld it, but it's a complicated and tough question, and the optics are not good. But the point is it no longer can be enforced no matter what. BDO on top of that has agreed not to enforce it. And to top it all off, Mr. Giacomoto from the beginning has refused to participate in the identified process for naming an arbitrator. All of that points, any one of those is individually sufficient. Each together makes it unavoidable that this is an FAA Section 5, or if you want to say a New York Section 7504 kind of case. The method for naming an arbitrator has not been followed, and therefore the court shall appoint a substitute arbitrator. And I'll note that we have suggested the AAA. Mr. Giacomoto has never suggested an alternative, and you know, we're not like wed to the AAA. If the court wants to select some other reasonable arbitrator, we're open to it. The point is, the parties agreed to arbitrate. BDO will not enforce the element of the provision to which Mr. Giacomoto from the beginning has objected, and therefore the court ought to appoint a substitute arbitrator. There are no further questions. Thank you.
So before, I'm sorry, before you sit down, maybe you can do this on rebuttal. I would like a request that you say what is the narrowest, most direct path for this court to decide this case so we get to that outcome. Deciding as little as possible pursuant to, you know, well-established rules of appellate decision-making.
I will say, I think it is simply the failure to follow the appointment method as a matter of fact, but I'll think more about that and I'll build that answer.
Thank you. Thank you, Mr. Kimberly.
Good morning, Your Honor. It's Lindsay Cooper. We filed a joint brief. I'm the attorney for Jasco Enterprises, and Miss Tiffany Joseph Goodstein is here for Eric Sabota. However, I'll be arguing today. Just to jump right into it, that I would agree with your comment, Judge Shanker, that generally speaking, when you are drafting a document and you use the phrase or otherwise, that is generally meant to not say different situations, but it's similar situations. And I believe that is the case that we cited in the Bengay case, that or otherwise means similar situations. So when you look at the phrase, as we commonly write as lawyers who write briefs all the time, y'all write opinions all the time, that when you have words and you use or otherwise, it is meant to elaborate that we are talking about similar situations. So when you go into the sentence that we're talking about, it's any controversy or dispute relating to this agreement or the partnership and its affairs or otherwise. So it's the partnership and its affairs or otherwise that is the similar situations that or otherwise is expounding upon. What are those similar situations or otherwise was put in there for that fact? So if you read it in the common sense, the final section after or otherwise is arising between a partner and a partnership. And that does encompass just those disputes. And if you continue reading through the paragraph that Judge Howard talked about, that it only talks about, it goes into the exceptions. Okay, you have to, disputes are, have to be done in accordance with this section, except disputes where a partnership and a partner may seek provisional remedies, injunctions from a court, and any accounting provided under this agreement to be conclusive between the partners and the partners agree to be bound by it. So I think it's very important to note that they include the accounting in there, that a former partner who leaves a partnership may disagree with its undistributed earnings. He may disagree with the amount of his retirement that's provided for under the BDO agreement. That certainly would apply to a former partner. So I would agree that if you're reading into the exceptions and they use the former partner as a term of art in section 14.3 of the agreement, 14.4, 14.5, which explicitly says for use of this section, partner will include a former partner. They're drafting that using specific words with specific meanings.
So if this was so common sense, why didn't your client make this argument 4 years ago?
It's a great question, Your Honor. And, when it came up on appeal the first time, the first appeal, where Judge Deal made his comments, that was whether BDO had waived the ability to arbitrate by filing the suit. So it was a very narrow issue. They weren't focused on the terminology.
No, I get that, but
Yeah.
I mean, 4 years ago, you could have forestalled all of this litigation by immediately arguing in the trial court, not in this court. When it came up on appeal in the trial court, first thing you should have done, motion to dismiss their most application for preliminary injunction. And say-
As you.
Say
pointed out-
nothing about this agreement applies here. I mean, and 4 years went by and you didn't do that. So strikes me as odd that the trial court would reach out to do that.
Well, I mean, in some sense, the court, gladly, the court did notate it. And it was, I would agree, was not briefed and raised prior to the November 8th hearing. But the trial court, I think, when looking at it and deciding whether or not there's an arbitratable issue. So BDO has the burden to prove to the court, like a jurisdictional issue, that there is an arbitratable issue that can be sent to arbitration. And the court, with this disconcerting eye, picked up on it the day before, asked to be ready to argue it. And in fact, most of the November 8th hearing was about.
But when,
Whether-
I mean, when then ever would the party presentation principle apply, if not in this case? Where you've got, two sophisticated parties represented by counsel and, a private dispute that doesn't have widespread implications and 4 years of litigation to make the argument. Not a criminal case, a civil case. I mean, it seems like this would be the core of saying, even if the trial court was right in flagging this issue, too bad,
Yeah, Your Honor, I mean, they're good points. I mean, delay was caused by a lot of things. First of all, the initial appeal that took some time, as well as this suit was started in April of 2020 with the pandemic. So there's a multitude of reasons. But again, I get back to the concept of, it was not raised specifically by the private parties in the contract, but determining whether or not there's an arbitrational issue is akin, in my point of view, to a jurisdictional issue. And a court at any time can independently look on whether it has jurisdiction or there's an arbitratable issue. So yes, it was not raised, but I do believe the court has a discretion to bring up issues that affect its jurisdiction over the case. So I do not believe it was waived. We have not really engaged in discovery. Like you said, I mean, we're still trying to decide an arbitratable issue, which we have been fighting, which goes to the
And
point.
counsel, let me ask you too, before you go too far along, under basic principles of arbitration as well, any arbitral tribunal would have to determine its jurisdiction and look at that question in the first place, right?
Yes, Your Honor, but Judge Kravis called it first. So it could have been raised there, but it was brought in the trial court, and here we are.
I was
No,
just
no, but
asking
it
to make
goes
the
to
point that it's not
whether,
gone.
I'm sorry, go ahead. But to follow up on Judge Howard's, not only did he reach for an issue that was not presented by the parties, but he reached for an issue that we have said is for the arbitrator in the first instance, right?
But again, I don't believe that's quite correct, Your Honor. I think the trial judge has the ability to read the provision and determine whether or not there is an issue subject to arbitration. And because Mr. Josh Sabota is a former.
Whether there is an arbitration agreement,
Pardon?
whether there is an arbitration agreement.
That's correct. If we don't fall within the provision, there's no agreement to arbitrate.
There's a question as to whether there is an arbitration agreement, and then there's a question as to whether this particular dispute falls within the arbitration provision, right?
Correct.
Two separate questions?
Yes, I believe we're talking about the latter.
Correct.
Yes, ma'am.
And that what we have said is for the arbitrator to decide.
Oh, no, Your Honor. I think that's why I was trying to correct you is the position is the trial judge can look at the provision and decide whether or not there is an issue that is subject to arbitration under the agreement.
Okay.
I do think that that is something that was properly done before the lower court here. So when you read all of the former partners, and Mr. Jai Sabota is not a partner, there's no arbitratable issue. So then we move on to whether or not the provision is unconscionable. And I understand that Mr. Kimberly said that unconscionability doesn't affect this court's decision, but I certainly believe it does. Because if the court finds that the provision is unconscionable the way it's written, both substantively and procedurally, that if it's unconscionable, then you have to strike the whole provision. And the question becomes whether or not the way the arbitration provision is exclusive. Is it a dominant intent of this arbitration provision that it be held before certain arbitrators in what rules?
So that comes from Marchant, right?
Pardon?
The dominant intent argument you're making comes from Marchant,
Marchant, and it's also the federal decisions that follow Solomon Brothers.
but pre-FAA Section 9 and New York CPLR 7504.
Yes, but the courts have upheld Solomon Brothers through it, that they say if the dominant intent of the agreement is to arbitrate in front of a certain arbitrational panel, and it cannot be done, then the whole provision fails. You can't sever it. So there's two concepts here, Your Honor. First, if the arbitration provision on its face is unconscionable, you can't sever the unconscionability. The whole provision fails. Secondly, if you cannot comply with the arbitration provision, which is the case where they're talking about the BDO has now changed its form from a partnership to a professional corporation, their argument is there's no more partners to arbitrate from. There's only principals there's no partners. And that's an issue of corporate structure. So if either of those two fail, then the whole provision fails if the court finds that the dominant intent of this provision is for BDO to arbitrate before two of its board of directors and three partners. And the lower court, I believe, properly found that, yes, it was the dominant intent of the parties to solely arbitrate in front of BDO directors as well as partners. And the language is the first sentence is the or otherwise sentence. The next two sentences of the very same clause instruct specifically how the arbitration is to occur. It is, it says any dispute or controversy shall be considered and decided by an arbitration panel consisting of two members of the board of directors, other than the chief executive officer, selected by the board of directors, and three partners from the partnership's practice offices are members of the board of directors. And it goes on to say that the three partners can't be from the same office where that partner was when he filed the complaint. And again, it used the word partner, not former partner, in that last sentence. So if that is the dominant intent and it doesn't provide for another forum in which to go arbitrate, that the provision will fail. So first, looking at the unconscionability, that I believe Judge Deal and either Mr. Kimberly admitted that they wouldn't want to defend the concept of arbitrating a $40 million claim in front of your own board of directors and partners. So then you fall back on procedural. And what Judge Deal pointed out is under the New York case law, there's this sliding scale that how the more offensive the provision is, the less procedural unconscionability needs to be shown. And I think his exact example in his opinion was 2 parts procedural unconscionability, 98% substantive. Substance being, I'm going to arbitrate in front of my own board of directors that have fiduciary duties as well as a pecuniary interest in the outcome. So what is the procedural? Well, we have a provision on page 33 of a 44-page document. The provision is not titled. There's no boldness. Mr. Eric Sabota was a 1% shareholder in RG when it was being taken over. As most people know, 1% shareholders are a very small minority. They don't have a lot of decision-making power. When he testified and we referred to in the brief, when he asked about his ability to negotiate, Mr. RG told him, don't waste your time or money getting a lawyer.
Sorry, Mr. Cooper, how does your argument on unconscionability strike, causing the entire section to be struck?
Yes, I mean,
Well, how does it work with the Brower case out of New York that says even in the case of an unconscionable provision, the court shall substitute an arbitrator?
that's good. That's a great point. In the Brower case, I believe that like many of them deal with fees or the location. So it's some concept that's ancillary to the provision. So it's not the core of the provision. So the big one was the Gateway Computer as well, that they had to go to ICC, but the fees were $2,000. That was twice as much as the computer cost. So they went to a different form where they agreed that the fees could be different. Here, we're talking about the very core of the agreement, not some ancillary issue.
You back to
so-
the dominant intent point.
Yes, ma'am, and that is read in the four corners of the document because it is specific about who has to arbitrate and how they're selected. So that indicates the dominant intent. And really the case on point here is the Solomon case as well as the Dover-Watley case. So for example, and those cases also are very akin to the changing of the name. So in the Solomon case, they sent it to the NASDAQ to be arbitrated. And the NASDAQ took it, but they refused to hear the claim. So when it got back to the court, they said, well, pick a different arbitration provision. And the Solomon court in the Second Circuit said, no, you provided only the NASDAQ could hear this arbitral claim. They refused to hear it because it was the exclusive arbitrator panel. There was no other arbitration panel provided for that we will hear it. We're not going to appoint it differently because the dominant intent was it solely and exclusively to be with NASDAQ. The same in the Watley case is true where it lost its NASD licensure. So it couldn't arbitrate in front of the NSAD as a non-licensed member. So they refused to take it. And the court again said, even though you losing your licensure precluded your ability to go before the NASD, that fact alone doesn't allow you to appoint a different arbitrator because you solely and exclusively identify the NSD to be the people to hear it, it fails.
But so do you agree that you have to establish both procedural and substantive unconscionability relating to this provision?
Your Honor, I think the Cross case, that is the older New York case that talks about a board of directors that hears it, says just on its face, it's unconscionable because it's illusory, because you have a fiduciary duty. You know, the very purpose of arbitration and being in front of a tribunal is to have an independent hearer of the issue. And if you have a fiduciary duty and a pecuniary interest, you're not independent. That case has been, and I don't think Judge Deal accepted it on its face in his opinion. So, you know, if
Yeah,
this
but
court takes a different view, it can under the Cross case and just say the provision's illusory. But yes, most courts are going to look to that sliding scale of both substantive and procedural unconscionability.
And what's the procedural unconscionability here? This is the,
Yes, ma'am. It's the very fact that Mr. Sabota, I believe he had about 3 weeks with the agreement. He was a 1% shareholder. The provision is way back 33 pages in a.
my experience, that's where arbitration provisions usually are in most agreements.
Yes, Your Honor. Sometimes they're bolded though, because they have significance. Sometimes you have headings on sections to identify what that section is. This one,
Now, he also signed these supplemental agreements, which I guess preceded the partnership agreement, but they
Yes,
do
ma'am.
incorporate by reference that specific provision.
it did,
Don't
it
they? Yeah,
did
They
reference
do,
it.
yeah.
And I would also like to point out to you that in their interrogatory responses that are in the record, specifically was asked since 2012, November, when he became a partner, to July 1st, when it changed his corporate existence to a PC, had the arbitration provision ever been amended? The answer was no. The other question we asked was, how many acquired partners came in during that time period? The answer was 421. The other question asked was, how many organic partners, meaning people that worked their way up and became a partner? I believe that number was 684. So we have almost 1,000 new partners being admitted in this 8-year period, and never once was it changed, which I believe is evidence that, that is a provision that is not negotiated. It never changes, and it never was changed. So unless y'all have any other questions, Your Honor, I see I'm out of time.
No questions. Thank
Thank
you. Mr. Kimberly, come on back up.
Thank you, Your Honor. If I may, well, I guess Judge Ruiz, why don't I start with a straightforward answer to your question?
Thank you.
I think on the first issue presented, the easiest and most straightforward way to resolve the case is the line of questions from Judge Shanker concerning waiver. And as Judge Shanker rightly asked, if the party presentation principle doesn't apply in this case, it's hard to imagine where it does. After 4 years of litigation, there was nothing to prevent Mr. Giaspota from raising this issue in his very first filing on day one in the case, and he didn't. It only came up 4 years later when the Superior Court, 18 hours before the hearing, sent an email to the parties. So I think that's the most case-specific, easiest way on point one. I think on point two, it's simply to observe that the method has failed as a matter of fact. And that's just to say nobody disputes that Mr. Giaspota has not followed the method specified. The method specified is cooperative. The parties have to agree on who gets appointed to the panel. When one party refuses to participate in that discussion, the method specified for appointment of an arbitrator has not been followed and fails, and that triggers section 7504 and FAA section 5 as a matter of simple and straightforward fact. Now, on that point, my friend on the other side has said that the issue is there's a dominant intent to use that provision, but that conflates two different issues. What my friend on the other side was talking about was the remedy when a provision is found unconscionable. The question of severability is a question of party intent. Given that a provision is found unconscionable, if it is found unconscionable, the question is sort of a counterfactual. What would the parties have intended to happen with the broader provision within which the unconscionability is found? That is not the question presented by section 7504 or section 5. These two statutory provisions are authorizations, and as you pointed out, Judge Shanker, they're in fact instructions by the legislature to a judge to do something when something happens with respect to arbitration. That something is a failure to appoint the arbitrator. So it's not a question of the party's intent. It's a question whether something has happened with respect to the appointment of the arbitrator. And I think there are three different ways to conclude that the appropriate trigger for that provision has happened. And as I say, I think the easiest is just to say that the method has not been followed.
But the method that Mr. Giaspota would have been required to follow would be to not agree. So the members of the arbitration panel shall be mutually agreed to by the board of directors and the parties. That's what you're pointing to, right? And you're saying that he could have just invoked that and said, I don't agree. And then there would have been further discussion, but because he hasn't even done that and has refused to even participate in the step leading up to agree or not agree, that's why it's failed? Is that your?
I think it's failed just because, as a matter of fact, the parties have not worked together to name an arbitral panel, and an arbitral panel has not in fact
Right, but I mean,
been constituted.
that's, the provision says that whoever makes up the panel would still be members of the board of directors, right?
Yes,
And
right.
so he might quibble with, I want Joe and not Mary. But he's saying I shouldn't even have to do that in the first place, right? So why would he engage in that conversation?
Well, absolutely, Your Honor, but that's a question of why it hasn't been followed. And from our perspective, I mean, I think that's a red herring. He can have any number of reasons to refuse participation. And my position on this point takes no position on whether or not he's justified or unjustified in refusing to follow it. The fact is, he hasn't followed it. So now the question is, do we get relief under section 7504 or section 5 of the FAA?
Right, but I mean, I think it does sweep in the unconscionability argument, and his point would be, because he would say, it's not that I'm not following it or refusing to follow it, it's that I shouldn't even have to engage in this discussion of whether to follow it because it's unconscionable that you would make me sit in front of a panel of my former partners.
Right, and so I think that points quite naturally and easily to the second reason, which I think dovetails with the first. I mean, the two are factually linked, which is that BDO has agreed, therefore, not to enforce this provision. And again, the clearest case is Rigoni. It says that unconscionability, again, is an equitable defense. And a party who asserts it as a defense to enforcement of a contract can't complain when the party against whom the defense is asserted says, okay, you say it's unconscionable. I disagree, but in all events, I'm just not going to enforce it. Let's move forward with the agreement as though that weren't a part of
But
the
wouldn't that
contract.
then mean his argument would be that you're agreeing not to enforce all of 14.7, which is the entire basis for arbitration in the first
No,
place?
because all he has asserted, now, of course, since we've made this argument, he's shifted his argument and said, no, I'm challenging everything in the arbitration agreement. That's not true. This is another reinvention of the case. From the beginning, his argument has been that the panel selection process is what is unconscionable. He has never argued that any other element of the arbitration provision is unconscionable. And so if what BDO does is say, okay, we won't follow the process specified for naming arbitrators, we'll use the AAA. That solves the basis that he has. It moots the basis that he has for arguing unconscionability. Now, I want to be clear, we don't think this provision is unconscionable, as the Florida courts and the Connecticut courts and all the others that we've cited at the various stages of this case have found. But what we are saying is nobody has to resolve that issue because we're not seeking to enforce it.
And
He
you don't,
hasn't.
and you're saying that it doesn't, that we can say that so long as a matter of fact, the selection of arbitrators under the clause has not occurred for whatever reason,
4 years on.
under New York law and the FAA, it just follows ineluctably that the court shall appoint arbitrators because the parties have agreed to arbitrate.
Correct.
Because you still have to have that basic agreement to arbitrate. So my question is then, and maybe it goes to this dominant intent, I don't know. Because I think there's no severability clause in the partnership agreement, is that
Correct.
correct?
Right. There's a waiver clause. There is a recognition, a contemplation of waiver of terms, but there is not.
There is a recognition of waiver of terms.
16 point.
Okay. Can we say the agreement to arbitrate survives and is enforceable, even if we assume, which we are not deciding, that part of it is unconscionable, the actual selection of arbitrators?
Yes, and I would point the court to the clearest and easiest citation for this is the Brower's decision, which concerned and asserted unconscionability in the selection of an arbitrator.
Mhm.
And the New York court there, in a published opinion, it's actually the only opinion that really addresses this issue as a matter of New York law in a binding way, says the solution is cut that part of the arbitration agreement out, remand for the trial court to appoint an arbitrator. It's what it says in the clearest terms.
So as a matter of contract law, under New York law, that's the appropriate way for us to proceed.
That's
why
correct.
New York-
Invoking section 5 of the FAA, and if you like 7504, they're essentially overlapping.
Yeah, but I was looking more at the notion of, can we still say that there's an enforceable
Yes,
agreement to arbitrate?
Yes.
In the contract, even though we, as I said, assume that part of it would not be enforceable because it's unconscionable.
yes, that's right. And I think the Browers case, for example, used mandatory language, as did other cases like BP Exploration, which we cite,
Mhm.
which used mandatory language actually quite a lot like the mandatory language here. It was mandatory language in sort of a process for identifying arbitrators. And the Fifth Circuit in that case said that the process had failed and therefore it was going to remand for appointment under section 5.
Mhm.
So this is done.
So
We've said-
counsel, that raises one question for me though. If we were to go your way and decide to remand for appointment of an arbitrator, is it your position that we should just be determining automatically that the arbitration agreement is enforceable and not asking the arbitration panel to look at that themselves?
You mean unconscionability? I guess they're enforceable in what sense? There would no longer be an unconscionability argument to make
Mhm.
because it will have been waived. The basis for the unconscionability asserted all along has been,
But you would agree that in terms of this argument that we're so concerned with made when it was raised and whatnot,
Oh.
whether there is a binding arbitration agreement that's agreed to under the terms itself.
right,
would be
and that it
something
covers the
that's-
dispute, is that?
Yes, that would
Yeah.
still be in front of the tribunal to establish its jurisdiction to start with.
Well, I think it's possible. I think we'd probably still make a waiver argument 4 years into this dispute that's something that is off the table, but certainly it's something that I'm sure Mr. Giaspotto would raise. I will add the question whether the arbitration provision covers this dispute is not a jurisdictional question. I mean, this is jurisdictional questions, of course, are non-waivable. This is just a question of enforcement of a contract term. It's a
But
private
it would be jurisdictional for the arbitral panel, right? Because they would not have any authority to decide the dispute if they decided that the arbitration agreement did not cover the dispute.
Yeah, I mean, I'm not sure that jurisdiction works in the same sort of Article 3 non-waivability sense before an arbitrator. I confess just not to know that. Certainly for purposes of the dispute as it was pending before the Superior Court, this was not a non-waivable jurisdictional question. This was just a question of enforcement of a contract term, which of course is waivable. If there are no further questions?
Yeah.
Thank you.
Thank you both. Thank you all three. The case is submitted. We now stand adjourned.
All right.